The testimony of Cherno Marena before the TRRC sheds light on the manipulation of the legal system during Yahya Jammeh's regime, particularly through the use of foreign judges and legal practitioners. Marena revealed that Gambian judges were systematically excluded from presiding over controversial cases as their rulings were perceived to be less favorable to the regime. Instead, foreign judges, often referred to as mercenary judges, were brought in to deliver outcomes aligned with Jammeh's interests. The role of the Director of Public Prosecutions, DPP, was especially scrutinized as it became a tool for the regime to fabricate charges against political opponents. Historically, this position had often been held by foreign legal practitioners, a practice that predated Jammeh's presidency and extended back to Jawara's government. The last Gambian DPP, O'Brien Cooker, reportedly held the office until 1978. Under President Barrow's administration, efforts were made to reserve the DPP position exclusively for Gambians. The rationale was that a Gambian DPP would be less likely to fabricate charges against fellow citizens due to the social and personal repercussions of such actions. However, Marena pointed out a significant challenge. Despite advertising the position multiple times between 2017 and 2021, no Gambian applied for the role. Marena also recounted a personal incident from 2006 when he misled the DPP by claiming one of the coup plotters was his brother to avoid involvement in their prosecution. He acknowledged a broader reluctance among Gambians to prosecute their compatriots, attributing this to cultural and societal factors. This reluctance underscores the complexities of achieving justice in a system where personal and national loyalties often intersect.
I understand that O'Brien Cooker, of blessed memory, last occupied that position of DPP in 1978. It's a long time.
Yes, indeed. After the change of government, the position was advertised twice, but Gambian lawyers were not interested.
We were talking about the abuse of certain legislations during Jammeh era. And the last one we talked about was the Economic Crimes Act. And some of the rather surprising features of that legislation, including the trial in absentia provisions. It contains an interesting revelation on some of the things that the government, with the right political will, can use to really deal with some of the findings of the Jammeh Commission. Because those are nothing short of economic crimes. And the trial in absentia provisions can come quite handy. Only deja vu or taste of your own medicine. So now let's move on to point number 2 in your write-up. That is abuse of the office of the DPP or the Ministry of Justice itself. But prior to that, perhaps we can talk about the office of the DPP in general. As enshrined in the Constitution. If you could recollect, would you say that under the laws of this country, the office of the DPP should enjoy quasi-independence?
DPP la office me alan ko atel marlin kitindir kunyal la banko kanjang atanyan na office nyana kel office me alan ko abetara loring afaye politiko to dunaje nyaadon kata da dunaje abetara loring afaye ata ala ko tawande afaye ko luwa ya fo nyame.
Thank you. Baraka, having lived through a period where the office of the DPP was used as the main tool.
Wato mi yalon ko ñin DPP ñin na office ni ya tale kaka joranti
to target or persecute people.
I
believe that was what informed the provision in the draft constitution to have an autonomous office of the DPP. Because over time, like I said, the office of the DPP has been at the center of most criminal persecution, so to speak.
But why do you think that the office of the DPP was so amenable or so prone to be used for political persecution?
Itala mira do mona ya sabu ke muna fanni office wala memu DPP la office di ka ke office di me alon ko politiko la ko ka tamandi baka wala pour ka deto la molka.
In my humble view, I think a major factor which has made this possible is the occupation of the office. The occupation of the office.
Those who are in that office, those who work in that office.
By non-Gambians. Because for the longest time, the DPP of this country has been a non-Gambian. But post 94, 1994, we've had very good non-Gambian prosecutors in this country. But I believe that a lot of non-Gambian prosecutors and DPPs were willing to engage in any kind of prosecution. Go ahead. Notwithstanding the ethical considerations of some of the criminal charges. In my view, simply because they did not belong to the society whose citizens were the subject of these prosecutions. So it was easy, because you were going to go away after a couple of years or after a few years anyway. So there was no risk of you coming back into the society and basically facing the consequence of some of the decisions you made, or some of the prosecutions you engaged in. There was also little empathy. There was little empathy. Towards people who were being charged left, right, and center. I believe the Mandinka say "Balafa belonga lebala."
Bala fabi lungo le bala.
That is to say that, sympathy is based on the person you know.
So that played a big role. And after some time, the Gambian lawyers who were working at the Ministry of Justice,
Gambia dingol mi yalon ko lawyer le muti be do ko la Ministry of Justice
either avoided the criminal division,
ke tankandir ke fannala ka do ko ke wo bundani ne ka fo me criminal division,
or left the ministry.
wala fanga eka do ko nyim fon bla fa ministry ni na do ko.
And as a result,
wo yatina
most of the prosecutors
mo jamal bi je mi yalan ko kitindir la le muti
and the prosecutions
ni miliyalon ko kitio ko wala karola
ended up in the hands of non-Gambians.
anatana laba molbul miliyalon ko manke Gambia dingolti.
As a former Solicitor General,
Solicitor General in command,
responsible for the administration of the Ministry of Justice,
itel marta nun kata do ko la karola ka do ko je ka je ay tama nyala me alon ko nyanda ka ke wala ministry me mare luwal ni kitiol tamandiri nyala.
why do you think there was a high attrition rate of Gambian lawyers at the Ministry of Justice?
Mane amira ko Gambia loyal me alon ko be ministry member luwal ni kitindiri kunyala e mansianu isiata je mansiaje.
There was a combination of factors,
ku jamal le bije mi yalan ko ne ka funyoma wo satina no,
key among which
wo ku kumal kono killing mo nyinati
was the remuneration.
ko mi wole ka min dila
Joro.
joro e ka min dila
Compared to what a lawyer can earn in private practice.
bi sina jibe momu yalon ko loyal len ma be do ko ke nga faya be jomin sotolano.
So a lot of people left to private practice.
yaje so wala tina mo jamal nata ne fonyo e tata ta ka do ko ke
Because
faya loya yato
Paid more.
at woto e ka joro soto no wolto bake
Some people
mo dol bije
also left
wol bota jele
because they probably were not happy
atu asike no fana e man content lenu
with the way the system was.
wato ning komin kol ka tamanu nyami abeke kan nyami
And for them,
du pritol
the best way was to leave the ministry.
min nyanta dorom wolen ka bom ministry bundanyindo
So I would say these two combinations
mba fala ko ning ko flol ni ka funyoma
played a role in the high attrition rate
wo kata fen
at the ministry over the years.
kata fenneti mi yatina wala yatina mol man siya mi yana ko Gambia dingol le milbe do ko la wo ministry bundanyindo.
I'm talking about Gambians shying away from prosecutions.
Donc ka fo fana ko komin Gambia no li buka pare wala buka la fike da dum komin ketindir kunyalto.
I would take my own example.
Mbatalam fongol la misalo mbatalam fongol.
When I started my career at the ministry,
Wato min yala nganna do ko dati ministry bundanyindo.
With all humility,
Mbem fanjila bake de bari.
I was touted to be a very good prosecutor.
Wato ndeketa multi mi yanko nakitindiro no bakele.
I was doing well in criminal prosecutions.
Benna do ko ke kanga nyamale komi nana taka mol kitindi miliana ka kuja obaroke.
In 2006,
2006 sango kono.
sometime around May, June,
kata watela wala May karo kata fo June karo kono.
there was a day, on a Friday,
abenta jumalungo le fi.
when almost everybody had left the office.
Telefon phone sa foko fa mo be seitala nungi bota office oto.
The then DPP
Wato mi alon ko wala kitindi la nyaton koti ka fa DPP.
called me.
Name, please.
Told Fagbele. Emmanuel Fagbele.
Ka fa Emmanuel Fagbele.
Called me to say that I should stay, beyond the Juma prayers.
Anata fonyo ko kominsa si nganata na fonin jumo tata tambita.
When I asked why,
Kabinga nyininka mun dalile wasab.
he told me that there were some people who were going to be brought to court.
Konyo ko molle beje mi yalan ko nyanda ke samba kiti yo
And these people were the 2006 Ndur Chamku, suspects.
No nyulmo molle de mi yalan ko kon dur cham la wo kudeta bayri ngo min keta wo mol nyi yemel tumi koy dabije wo mol
6.
I felt very uneasy
wo man fam mutano bagay wala
because it was very irregular
ado mu fenne de mi yalan ka man nyanna ka ke
that people would be brought in
komi be mol natila nan
on a Friday
juma lungola
after Juma prayers.
adara juma salo keta foko pare.
And I didn't know what had happened to them. I mean, not because of, I suspected that something had happened to them as the tortures were narrated at that time.
Malong muna ketela de bar coming ya foja nyamen ko coming tajire yal mi yalon ko wolle ketela wo wato kono.
But my conscience
But im fon hakilo temboto
didn't really allow me to be part of that process.
man sondi no prunda bula wo ko kono.
So I went to the DPP.
Nata na murun DPP kan.
I quickly thought about an idea.
Ngam sita dolo ngam mira katabake.
I had known one of the accused persons,
Mo kilimbi je mi ala ya 2 million ngalone.
Aliou Job,
Ika faya Aliou Job.
whose brother was a good friend.
Wala doko wala koto mun na terima kende balti.
And I told the DPP
Nata for DPP nye ko.
that I am conflicted
Ngai ko nyen ko fulol blatam bulu nyokono.
because I've got a brother in this group,
Atoko ngam osodol mi ala ko ndoko lemma da bu
that I cannot be part of the team that would be the prosecution on that day.
andon tendata bulan mol kono mi ala ko nyenta ke kitindi wolungo nyi.
And since then,
Abru wo wato kono.
I didn't feel easy
Man si mam famutano.
being in the criminal division.
Min katara wo di wo fanna nyi ne ka fa criminal division e ka mol kitindi kujo ke lali ke kitindi dami.
I asked for a transfer to the civil division.
Nata fo ko pour yen sawnde dula do mi ala ko mol mi ala da mol ka du nyole le kitio ka ka dami.
Which was granted.
Nata na so wala.
So this was something that was regular.
Mo feneti mi ala ka aseke nole.
You don't want to be part of that system of prosecuting people that your conscience wouldn't take.
Comme ima ida manya na bulala ka mol kitindi mi ala ko ita fon ima hakil tenko soto wala karola.
You either leave the ministry or you leave the criminal division.
Min bije walem ibe dahala ministry do ko wala ye sawnde ye samba dula do.
Do you realize that since O'Brien Coker of blessed memory, we have not had a Gambian DPP?
Fa hakilo sinyi mudano ka bring aboda Brian Coker me alonko alama ala yam fala me kabri oboda je man Gambian DPP masoto jam.
I had actually thought that Fatou Bom was DPP, but maybe she was deputy.
Hakilo ya mutako comme Fatou Bom asikenu wo keda DPP ti bari we alfa wonde.
You would know.
From deputy DPP to Solicitor General.
Abo deputy DPP no langola kana ke Solicitor General.
So that's right. I mean, the absence of Gambian DPPs, I think, played a big role in the utilization of that office. Because Gambians would have found it more difficult.
Coming bari Gambian dingol wal mantaraje coming ka DPP ti wal fonga yatina fon natara no Gambian dingol bije wo fon be ko kolyande la no.
Because they would have to really live with decisions that they made with the people that they live with.
Kato foye ye lo ye kuntundirke fonga la mol mi yalan ko ni wala benta.
Do you think
Ya mira
that the fusion of these two functions
bunda fulol la tamandirinya
played a role in getting our attorneys generals to be compliant?
nyimbunda fulol pour ye tamande minister ka membe mare luwal nin kitindiri kunyalla.
That is the fusion of the function of attorney general and function of minister of justice.
Wala minister attorney general and minister of justice nyimbunda fulol ni munafi ni tamande akang fo ika ya mira ko ni deta akang ika sondiro ku ika tamande kendirino ko dollar me alonko ido lafita la nyamemba.
It played the most significant role.
Because one role, Minister of Justice, would be political.
And
the role of Attorney General should be an independent public function.
So when
you fuse these two functions, the political tends to override. Simply because that one same person becomes a political appointee.
Oh,
Could you shed more light in it?
Oh, certainly. I think you've said it all. Because really, I mean, the fusion of the two roles certainly led to, I mean, politically exigent decisions. over legal considerations.
In
some cases.
Wato dol bije.
So suddenly, I mean, in a situation where the two roles are separate,
sa woto mosa fogo ni wade soto da miyalon ko nyin do ko flol mi nyin yebe fatandi nyola
with adequate guarantees of independence.
Du inatana itandire ko itol mo kiliwo kilibe lole fayne yela do ko ke fay fenda
That would probably help
wobe makoro kala no bakal
in the basically distinguishing legal issues from the political.
Sadio ko wobe makoro kala ka fatam fansi keno ko la miliyalon ko woleta ta loi la fanala anin ko la miliyalon ko woleta ta political la fanala.
I understand that O'Brien Coker of blessed memory last occupied that position of DPP in 1978. That's a long, long time.
Indeed.
And I don't think we're really short of lawyers who could occupy that position of DPP.
We are not short of lawyers. In fact, after the change of government, because of this abuse of the office of DPP that occurred,
katuko nyinkanko nying DPP nyina office nyi kalanda tambe dokol mi yala ko wala ka keje
during the Jammeh regime.
Wato mi yala ko Jammeh be mararola.
The Attorney General Abubakar Tambedu,
Attorney General nying Abubakar Tambedu,
made it a point of duty
akala dokoti
make sure
kajeko
that the office of DPP
DPP la office nying
is occupied by a Gambian. Unfortunately,
the
position was advertised twice.
But
Gambian lawyers were not interested. And that is why, despite the office being a constitutional office, the position was not filled.
Since 2017.
Because the motivation was that we should get a Gambian. Because we couldn't get a Gambian, the position remained unfilled. So maybe it's an opportunity to, appeal to our learned brothers and sisters
to take
up the opportunity, even though it comes with less financial rewards than the private legal practice, because it's one of the hallmarks of our sovereignty. Sometimes it's actually embarrassing when you travel outside and inform or tell people that your DPP is a non-Gambian. So it goes to our national pride. That constitutional offices should be occupied by Gambians.
And you raised this very important point. The fact that they were non-Gambians make them more likely to be compliant with the visits of the executive. Be they legal or extra legal. My colleagues have just sent me this interesting example. And I'd like you to comment on it. Mrs. Mariam Denton was acquitted of charges by Justice Monageng. That should extinguish the case at least until an appeal has been launched, isn't it? But I do, according to the information received, Fagbele immediately stood up and objected to release on the ground that they had fresh charges of treason against her, which were not, in fact, before that judge. The judge just courageously stood her ground.
What
do you have to say about that example?
I have two responses. One is, Justice Monaghan probably did that.
Justice Monaghan, I work
not probably, was able to do that.
I work
Because he was a Commonwealth judge. And so she had all the assurances of independence.
So in that wala tina ya itandala ko kate aba fanso dola bala dogo kala anu hanifenda to bulala kona.
And during her tenure here, she did make a lot of very independent and sound judgments. Regardless of whose horse was God. Second response is that a Gambian DPP would not have done that to a senior legal practitioner of the Gambia. So that goes to explain my earlier explanation. The nationality of the DPPs played a big role in some of the decisions they were making.
But also the nature of the contract that the person had also played a role. Justice Monaghan was not so compliant simply because he was a Commonwealth judge and, as you said, had all the protection. The same could have applied to the DPP or the state council, foreign state council who are with the Minister of Justice.
DPP kan waranto state council bankola kitindirla kam me alon ko be do ko kam mansay.
What was the difference?
There was something interesting about the foreign technical assistance that came to Gambia. Some of them were working with their governments. And basically they were civil servants in their countries. And they were sent here on technical assistance. But some of them were not working with the governments of their countries. They were handpicked and brought to the Gambia. So they did not have the assurance of, employment with their government back home.
So ibajala ko ila masakunda miya ko wole be wole to kom e wol man litandir kela ko ila yeta do ko mina ba kala finante ambe teral lorine.
So that also played a part.
Fana keta fonati miya ko woda kata jela.
Because for somebody like Fagbele,
adu mom ya ka jaga Fagbele misalo la karola
we are talking about,
ikamum fote
he was not a Nigerian government employee.
Manke moti mialan ka be do ko ke kam Nigeria man sakunda le koto.
He was sent here on technical assistance.
Ya kina janne prana de maroke banko kanjang.
On contract.
Comme contrago la ka wati kono.
He was a private practitioner in Nigeria.
Temu molti mialan ka be aba do ko ke nga fay ne loya yala karola Nigeria banko kan.
Would the duration of the contract, in fact, have a role in getting these people to be compliant?
Contract ko nyina wato nyin fo fanam be kala kula de me alon ko abe la faran kala kudo me alon ko nyin do kulaldi pour yeson man sala man zaiba.
Certainly. I mean, the chances of extension of the contract depended on your, performance in the eyes of the person holding the last pen to the contract renewal. So obviously, if you wanted your contract to be extended, you would have to play ball.
Did Gambia government really have much of a choice on the quality of state council who are sent to Gambia on technical assistance?
For Gambia masakunda for ye fero sotela bampurka tamandi ni muola me alan ko ke kina njampuri na de maroke mansa Gambia masakunda la kiti la karola ba.
I believe there is an English saying that a beggar has no choice. And technical assistance request, in simple terms, was begging. So Gambia government did not have the opportunity to vet. Or to refuse persons sent by another country on technical assistance.
And with that, we got the good, the bad, and the ugly.
Indeed.
To the detriment of the public service.
Correct.
And the quality of some of these lawyers. Can you comment on that? Seeing we could not beg a gift horse from the man, we had no choice but to accept whatever we were sent. Tell us something about the quality.
Certainly, some of them were extremely good. And some came to Gambia to improve themselves. No. And some were even untrainable. No.
On what?
Some could not be improved upon. Yes, the quality was bad in some cases.
What do you think can be done to really improve this system? Considering, of course, that for the foreseeable future, we may continue to require technical assistance. What can we do to improve the quality of lawyers we receive on technical assistance?
And
the terms and conditions in which they serve us as a state.
Certainly the ideal. The ideal situation. The ideal situation
The ideal situation.
Okay,
the best situation.
Exactly. I mean, would be to have our own. Like all sovereign African countries. And of course, the Gambia Law School is continuously contributing to that, to make us self-sufficient in the legal profession. But until such a time that all the products of the law school would mature, and to become seasoned lawyers, maybe one way of improving on the quality of the technical assistance we receive is to probably, I mean, set the standards of experience, education, and competence that we expect to receive.
Mr. Marena, you realize that in the previous dispensation, the issue of minimum qualification for positions was observed more in its breach than in its honor.
Puru mola makamo puru niya ala makamo amarinya na niya palaso kankula amarinya na makamo men sotala.
Or was more honored in its breach than in its observance.
Ika korosi ni nya menna ani membe fana bekerinje ikafatale.
That is correct.
Well.
So would you suggest that insistence on minimum standards?
Ibe yimfola ko puru ama hanara ma besi but hanara makam amarinya na makamo nying ala lord laning na tembedar.
Insistence on merit.
Nyenna tala tukula ning amarinya na kaito nyinna beteyal
is key to this.
Fonang la farangonti nyindo.
Certainly, that's what I meant by, I mean, setting certain minimum standards that people who come in to help us should have.
It's been suggested that Justice Isauko, also in the Hamadba case, stood his ground on refusing to comply with the wishes of the executive.
Afanalota Hamad Bala case to Puru Golem Yindiko, Kamen Dita, Puraya Taman, the Hamad Bala case to Avalantawala.
And the view is that he too was the judge too was a Commonwealth judge.
True.
So the nature of the contract the person received played a big role.
Not only the nature of the contract, but I think the appointing authority also would be equally important. Because obviously with an institution like the Commonwealth, you can be assured of not being unlawfully terminated. If it's a Gambia government contract, I mean the contract is as good as the paper it was written on. You could be terminated at any moment. Yeah.
With regards to the position of DPP, of course, has the Ministry of Justice considered the terms and conditions of service?
wala nyindi amare nyini ata do gola nyanna bulala sartol din tamande bulol men no ma fay ka ministry nyin kala mutandira folo ba o mare nyina palaso nyina.
Because the position of DPP should ordinarily the qualifications for position of DPP should ordinarily be at least as a minimum that of Court of Appeal judge.
Adun DPP office woni afuta nyaaw nyarande nyam ala londo la kalso kam ala makam wa nyanda kam mensura londo la karola a nyanda kila makam londo la temi alon ko be kayto mensura be kala jojo la qualification kilingolti.
So if the conditions of service are not as attractive, definitely.
So ibaje la wona ninga adra sartol nyimi alon ko ye wala landi o palaso nyina kam ninga adra manke sartol mi alon ko ay mo kontan.
It would be difficult to attract the qualified people.
At least
qualified Gambians.
That is very correct. In fact, one of the successes of the former Attorney General,
Attorney General Nunto,
Tambedu, was the approval to improve upon the terms and conditions of all state council, the Ministry of Justice, and basically to be at par with that of the judiciary. So the DPP's office, as you've rightly stated, the terms and conditions are now pegged at that of a Court of Appeal judge. And this has been there since January 2020.
And the possibilities of national continued legal education would also help.
Wolem nyindi fanam bu ka tentenka banku be karandiro ke wolem nyindi ko luala karola o fanam be kala kulen menon ko abe de maro kelale.
Certainly, I believe that is a responsibility that lies not just with the Ministry of Justice,
Ministry of Justice
but with the General Legal Council of the Gambia,
General Legal Council Gambia,
and the Bar Association. Because continuous legal education, as it happens in more advanced jurisdictions, is applicable to all practicing lawyers.
In fact, in many jurisdictions, you would have a proficiency test in order to maintain your eligibility to practice.
Jama banko dol me alon ko wolke mari koto bole fam pour isa jago janni be la o palaso nyingi iba tuno la je waranto jani ba sotola,
which we do not have in this country. Once a lawyer, always a lawyer.
Yep. It's true.
So now let us move on to the issue of political interference in the justice sector. Say in the judiciary, to be more precise. I do know that Gambia has been said to have mercenary judges. We have heard that in both political and legal circles for a long time. Can you tell us about that? Was the accolade deserved, and why?
Well, I mean, like you've rightly stated, this was a terminology That was coined to refer to certain judges. And mostly foreign judges.
And
these were judges who were not necessarily sent on technical assistance. But who came here on their own with legal qualifications and probably little alternatives employment. And when they were appointed as judges and given all the perks of office, they would do anything to please the people who gave them those contracts.
And who would be that?
Because the appointing authority for judges is the president. And so, yes, I mean, if you look at some of the decisions that were made by certain judges and magistrates,
I
mean, you could say it was a justified tag. Be called a mercenary judge.
Kindly give examples.
Well, I mean, there were judges here who, like Justice Paul, for instance.
Justice Paul.
I mean, who everybody believed was very close to the presidency.
Another interesting choice of words. Close to the presidency, you're referring to an institution. You're not saying close to the president, referring to the person.
In this case, I'm using it as a single entity.
He was close to Yaya Jammeh.
Yes.
Why did you say that?
I have never seen him, but I have heard, just like everybody did here, that he would even go to Kanilai during the weekends. So,
what nationality was he?
Justice Paul was a Nigerian.
Justice Paul was Nigerian.
A judge going to the home of the president?
That was the rumor in town.
And could you tell us about some of the cases that he presided over?
Maybe the most obvious one would be the Baba Job case.
What can you tell us about that case?
Well, I mean, he's the one who presided over the case. Convicted him. And I believe sentenced him to up to 9 years in prison or so. Yes.
And your belief is that, well, it's not out of the ordinary that a judge sentences an accused person. That is normal. That is what judges do. So why do you cite this as an example?
No, I mean that is the probably most famous case that he had presided over.
Wala nyindiko nyine kata diamote mi yalan ko ate fon la kata kiti taylati and wala darajata mole wala long bake.
What makes it famous? Is it the personality who was charged, or is it the violations of rights that punctuated that case?
Mune ya sabo ke wala dia mo ni bawa job lo case ni aketa case mi ko daraja ta baga fo mola me alon ko ata aba kitiyo ni kono bam fo warando fo tumir de bundal mel lata kan wala case ni wala daraja ndi baga ba.
It was a combination of the two.
Ni ajibe aflo belem.
Because obviously everybody knows that Baba Job was probably one of the most powerful men in the country at the time. And so to basically drag him to court was a big national event. And of course, it was during that case that his lawyer, Usman Silla, had an attempt on his life. And a lot of people believed that was as a result of his defense of Baba Job.
But of course, Mr. Usman Silla was not the only lawyer for Mr. Baba Job. Do you recall who else represented Baba Job?
There was a big team of lawyers. But my Fati stands out.
But my Fati Londi Canada.
As also one of the lawyers in that case.
There was an attempt to assassinate Mr. Usman Silla.
Mr. Usman Silla Prukafa.
Do you know if anything happened to Mr. Fati?
For yala na foku soron laba me alonko wala fananketa Mr. Fati laba.
Mr. Fati was also involved in a near-fatal accident.
Mr. Fati fana adabulata nung accident o konolde mi alonko accident kolem balem.
I believe on the Senegambia highway.
Lata ko akete nun Senegambia sila baleka.
And certainly, I believe he has said that he also believes.
And atefana ya fole ko.
It was not a real accident.
It
was an attempt on his life.
The commission received evidence that Baba Job himself was executed. By the junglers at the RVTH.
And the Mendio Kala Willem Jungle, the Yakala Diamond Woltom Bankola Loptan Badodi, RVH.
But not only that.
But I'm on Kewdrum.
Commission also received evidence
Commission said and drove an
that he had finished serving his term.
Oh, Lua is Bulume Muromen Kala, Willem Sanji Konondo, I all la fire bang.
Of imprisonment, still he was not released.
Kasoro and Haninkabi Imasona Kabula.
And held in prison unlawfully.
What
do all those facts put together indicate to you?
Well, I think they indicate that his case was a very politically motivated case. It was not simply a case of owing the customs and the ports charges and duties. Which was the major tenor of his charges.
And the interference with the judiciary. Could you, as far as you know, tell us how that was done?
I never worked with the judiciary. But we've had stories of directives being given to judges. And basically, judges being compromised.
Compromised how?
Basically to either convict or to impose sentences that are beyond reasonable.
Case kafoko buluaya bulole kanyenyanta kela kasolto nyala miyala ko ni ajibe wo fonga manyana kake.
But we understand, at least from statements, that the NIA is actually infested the High Court during some of these politically charged trials.
Yes, certainly.
What would be the impact of that on judges?
In my view, I mean, I would not say that the presence of the NIA in the court premises was the factor that played on the minds of judges. Because these were operatives who probably people didn't even know were NIA agents. I think they were there just to report on the atmosphere and basically who was there and who was not there, to show solidarity to people who were charged, probably. I don't think that's where the influence on judges came from, in my humble view.
But within their open presence, help indicate executive interest and therefore instill fear on the minds of judges.
Like I said, I do not think that these were people who were openly recognized or known by everybody to be NIA, unless if the judge probably has some other way of finding out or knowing. Because these were low-level operatives, like I said.
Human rights reports suggest that in several cases, a judge would receive a call and would come out of chambers and hand down a ridiculous decision. The Commission has heard of court-martial's pronouncements by judges indicating that there is no evidence against a particular person. The judge receives a call and soon after comes back and sentences the person who just moments ago had no evidence against him, but is sentenced to long terms of imprisonment.
Yes, those were stories that we all had, and you know. And there is no reason to believe that they were not true. Knowing the nature of some of the judges.
Can you expand on that? And I underline the nature of some of these judges.
I believe we spoke about the tag of mercenary judges. Who had no compunction to do things that will please the president. Even if they do not receive directives. Less of when they have received directives.
We have received information about a magistrate Kayode. Who imposed outrageous bail conditions. Which were clearly unattainable by the suspects who were brought before him. Such as requiring a former retired Inspector General of Police to come and give bail, sign a bail bond for you, or a former CDS of the army. Or a permanent secretary. Onerous conditions that he knew that the suspect would not be able to satisfy. Which in reality would amount to constructive denial of bail.
Yes, I believe that was part of the systematic desire to deny people bail who are facing the most trivial of offenses. If I recall right, even the Honorable Halifa Sallah faced such onerous bail conditions in one of the trials that he was subject to. And as you've rightly stated, that is basically saying you are given bail, but you will not go free.
And it's also alleged that some would do the most outrageous, as in admitting confessionary statements that were not even signed by independent witnesses, and a judge in question is Abeke.
Mudol fawol beje me alon ko ika tumiro lega ika kuma kan sotebul me alon ko sotebul de tole kon andu ni samba kiti wala fana o tumiro nyim fan dol beje me alon ko ben kaw nyinin ka jojo do membe ko magistrato ika fa Abeke.
In the case of William John Juve,
misal fe ke mo kilin beje ala case ka me William John Juve.
Are you aware of that?
Yo kala mutale ba.
I can't recall. What I can say is that there was a trio of magistrates.
Mosaba.
Who were notorious, bending all known rules of procedure. Or impose outrageous sentences. You've identified Abeke. You've identified Kayode. I think there's another one called Magistrate Alagbe. And like I said, these are all people who are, if I would be allowed to use that word, hustlers.
Safo no nyulbe mo molete mi yalanko natare sembula no jere ko me ka kul tamande nyamani silo bakata.
They were hustlers.
Hustlers, okay.
They were not technical assistants.
Manke molde mi yalanko ko mi ye kina jene pour yena demaro ni.
So probably that explains
in fact, Abeke and Alagbe are reputed to have remanded everybody arranged before them.
Afotala ko momo morondi yalanko ye tumi ye nati tol nyati lingola iki samba mal dul wala ki samba remand,
especially in cases where there was the slightest tinge of executive interest.
Surtout me yalanko tumi do keso dol me yalanko o mari ni ya nati nyati lingola andun sobo beje ko executive la na sulo beje wala mi santon kolti masala karola wala sulo sota kes nyin konole jama o mari ni ka samba remand ne folo.
Like I said, I wouldn't put anything past them.
Were they that bad?
Yes. I would not be able to confirm each and every one of the cases that they handled. But I won't deny anything that I hear which is outrageous that they did.
It is even suggested that as judges they took direct instructions from former Chief Justice Ajim.
Former Chief Justice
on disposition of cases.
Like I said, I won't put anything past them.
So you're suggesting therefore that they were so bad? That they would do all these terrible things like taking direct instructions from Chief Justice? And deliberately flouting well-known rules of procedure? Just to satisfy the executive interest?
I would say they would do anything that would help them maintain their contracts.
Mba fola ko itol ibe ku kala kaje ko dorong e do ko mi yalan ko ya dila wakana tay bulu ye continue wo do ko nyen.
They deserved the title mercenary judges.
Munta kay pour moya fay mercenary judges wala jojol kiti telal me alon ko ye jole pour yena ka kiti ote nyala me alon ko anintili mo manta pour ronka mol nya se wondi men yalon ko wolle ta do ko amunta ajarata la pour ke mandi wotola.
Indeed.
So abhorrent was their conduct that they committed the greatest disservice to the Gambian people.
Correct.
These were not the only three. There were many more. Do you think it's worth the while to continue to have judges under such type of arrangement?
These
hustler judges whose only loyalty was to their contracts.
Certainly. I mean, we should never ever have judges who are not here except on technical assistance from other benches around the world.
Manyana sonna kitindi tela la kotek miliyalanko e betarani banko le kanja ngeta bari mol miliyalanko e be balana banko kotengol le kan priye na yenan demana kitindiro kunyala.
Mr. Chair, I have just two more topics to deal with. I should be able to finish them in 30 minutes, I believe. Do we take the break now and return after 1 hour? or do we continue and finish for the day? I have no other witness for today.
Is the witness strong enough to continue for the next 30 minutes?
Yes,
the seat is not too hot.
Fine, let's go for the next 30 minutes and then call it a day.
Thank you very much, Mr. Chair.
But where, can I just ask one quick question? Where was the Bar Association in all this crazy situation that was going on in the country? Or did the Bar Association comprise majority foreigners?
Yaman kami nyini ka wala nyindi ko na nyin loya ka fo e tolbe no mintole wato mena nyin ku jawol bebe kala na banko kanjang.
Well, Mr. Chair, we setting the tone for the Bar Association to come and respond to all these things.
I want to hear from him first, and then the Bar Association will hear their response.
Indeed, indeed. Thank you very much. Mr. Marena, could you have a go on that?
Yes, thank you.
Marena ko fosi kuma fono woto bang.
I think the Bar did its part. In fact, there were circumstances where the Bar boycotted the courts of certain judges in reaction to some of the outrageous things that some of these judges did. I can recall there was a boycott of Justice Paul's court at one point. So the Bar did try to do what it can. But I believe it was swimming against the tide. There was little they could do beyond issuing statements, and in extreme cases boycott the courts, which also had its consequences on their litigants and their clients. But I believe if the Bar president comes in, you will probably be able to say some of the other efforts that were made by the Bar in reaction to some of these abnormalities.
Thank you. Counsel, you may continue.
My counsel.
But this conduct was not just limited to the judges. The magistrates were also involved. But judges who resisted the executive interference or disregarded what may have been executive interest and followed the law were also dealt with very badly. Was that true?
Very true.
Can you give us examples? We have been told about some situations or instances like the Omar Jabang instance, which you raised earlier. And there was Samsidin Conte. Brikama magistrate. There was also Ibrahim Jaite. There was this former Chief Justice Chauhan. And Justices Raymond Sok and
Justice Raymond Sok.
Could you dilate on these examples?
Certainly, There has been many brave and patriotic judges and magistrates who, like you've rightly stated, followed the law to the letter, did not allow themselves be swayed by political interest or executive excesses. Because the Omar Jabang you've rightly mentioned, I believe his dismissal from the bench was in reaction to a judgment he gave. Few judgments, I believe. One of which was the Andy Carroll case, who used to be the Deputy Accountant General, I believe, and was charged for some economic crime, offense. Because he acquitted on discharge her. I recall Omar Jabang also dealt with the case of Yusuf Saidi. And he also did acquit him. Because much to the chagrin of, the president. And his dismissal had to do with some of these decisions that he did make. And
one hallmark of the judiciary is security of tenure, which is critical for independence of judges. Correct?
Yes.
And this dismissal is just an attack to that principle. Certainly. In fact, I did hear at one point President Jammeh himself say he doesn't believe in the independence of the judiciary. That he pays the judiciary. You cannot have independence when they are being paid by the government. So I think was he reminded that he had it all upside down? He had no clue who was paying the judges. It is the taxpayers of this country. It is the people of the Gambia. Well, I wish somebody had reminded him of that. Except that he is a proponent, I believe, of the French acronym of L'État, c'est moi, is it? They call it. Which is the equivalent of a dictatorship. That the state, he believed himself to be the embodiment of the state. And Ibrahim Jaite, magistrate, Ibrahim Jaite, who is now a justice. Ibrahim Jaite, also suffered similar consequences. I recall it related to, one of the dictas of Jammeh that people should pray on a particular day, or Korite or Tobaski. Akilo blatala komi Jammeh fongola kuma kangoldo kafoko komi nin salo sida sunkar salo le wala banna salo lungo nyanta sodola mia wolungo fomole sali wolunga. And that whoever prayed on a different date no ni momo nata sari lungo la mia lanko yo lungo le fo would face the full force of the law. Loi bloba lale kana nyanta nyami or his law. Awala telefonga la loi.
And you had this sheriff from somewhere in the West Coast. I can't remember which, but is it Dasilame also? Who led his people to pray on a different date to the date that Jammeh had pronounced, or the Supreme Islamic Council had pronounced. As ridiculous as it sounded, he was arrested by the police and charged. Magistrate Ibrahim Jaite acquitted him. And he was dismissed. Samsudin Conte, you referred to as well. I believe he was dealing with the case of Said Matijau, who was working with the University of the Gambia. He was involved in some research, and as a result of which he was charged for some offense relating to the research that he was carrying out. He was charged and brought before Samsudin Conte. Again, he was acquitted. And the young magistrate also was given his marching orders.
But not only were they given marching orders, they were also subject to harassment by way of arrest.
Indeed,
I believe both Jabang and Samsudin were subject to police detention.
But this was not only limited to magistrates. Tell us about Chief Justice Chauhan.
Chief Justice Chauhan
In 2005, after they dealt with the 2015, after they dealt with the Langtombong Tamba and Sajo Fofana case. When they handed down a decision that was not favorable to the Jammeh government.
I believe for Jammeh, it made no difference, whether it was a magistrate court or a Supreme Court.
Supreme Court.
In that case, the Langtombong Tamba case, Langtombong and Sajo Fofana, I believe, were convicted of treason.
Langtombong ni Sajo Fofana yes loi bulo lai kana ko ye jamfa jawole sitino.
And at the Supreme Court,
kiti ba nyinto Gambia
and they were sentenced to death.
Nata foko nyanta ke fale.
And of course, on appeal at the Supreme Court,
Supreme Court
their lawyer, I believe it was Sheriff Tambedu, rightfully argued that under the Constitution, a person can only be sentenced to death if his conduct led to the death of another individual. Since the alleged coup d'etat did not result in any death, therefore they could not be subject to a death penalty. The Supreme Court agreed with the submission. And I believe they were, the death sentence was replaced with a life imprisonment. Certainly, Jammeh didn't take kindly to that. And the Chief Justice then was a Pakistani national. And the other justices, Justice Jibujane, and Justice Raymond Sok, were all dismissed. I believe the other judges were foreign judges. They had come from other countries. Interestingly, this was the decision that led to Jammeh's downfall. Because this was the decision which made us have no Supreme Court. In 2016, when he lost the election, he filed an appeal before the Supreme Court. But there were no judges to hear the appeal. And that's why we all saw on television when he called Ellen Johnson Sirleaf, the then president of Liberia,
Ellen Johnson Sirleaf, I will command the telephone
pleading that he should prevail on, I think, some Nigerian judges who he had identified to come and hear or to constitute the Supreme Court.
I mean, Qatar Nigerian kiti tela dolta miliyan ko wolle binatara wo kiti bumbanyin to purka atele ayo kiti ayo kuma kongal min dundi pour wol se jiber ke wala.
So sometimes, like I said, if you're digging a hole,
don't
dig it too deep. But this one was a hole too deep. Because it may have been possible for that election result to be overturned with the right judges in court.
Indeed, Chief Justice Chauhan left the jurisdiction in 48 hours.
Chief Justice Chauhan in Arana by Bango Kanjang
Jammeh left the jurisdiction few weeks after the election. But this was just not the only time he has so blatantly and directly interfered with judges who gave decisions that were not favorable. The present Chief Justice had once served as a judge of the Supreme Court.
Sorry.
And I do believe wrote the opinion on the immunity provisions, which were declared unconstitutional.
Ndum fana adablota molkono mi yalan ko wolle saferke e ka fani loi mi yalan ko e ka fa immunity mi yalan ko anyanta kalonu bari manata.
What happened to him during that time?
No, certainly, like you've rightly pointed out. I think it was Kemes and Jammeh who challenged the constitutionality of the amendments to the Constitution. I believe around the year 2000 or so. 2001 thereabout.
2001.
And of course, the current Chief Justice gave the lead judgment and upheld the challenge. And declared the amendments to the immunity clause unconstitutional.
And he was dismissed.
Yes, he was dismissed thereafter.
But even Justice Monageng
and Justice
Izauko were both forced to leave after giving decisions that were not favorable to the Jammeh regime.
I would add to that, I think there was also another Ghanaian Chief Justice.
Ghanaian Chief Justice do na tata nunjane.
I've forgotten her name, lady Chief Justice.
Yes.
Ajiman. Yes. Justice Ajiman.
Justice Ajiman
also had to leave the country under very difficult circumstances. In fact, I think she went into hiding just before leaving. And in fact, the Ghanaian government was very unhappy about that. And I think that has been the reason why they've been very reluctant to actually send technical assistance to Gambia.
With our own local judges or magistrates, they get arrested and detained. We examined the case of Jaite. There may have been a mistake. Jaite's removal and detention had to do with the transfer of a case, a discharge of the accused persons and transfer of the case to another jurisdiction from Birkama to Bundung, which was found unfavorable.
Magistrate Jaite wala bondo ngam faham je wala nyindi ko ay case dole sotaranum soronum Birkama magistrate court ayo case nyindeta aya bondi Birkama aya saundi nang bundung kadu nyinkama lako bundung Birkama kiti bunda nyimman sembo soro pour ko case nyinta wala tin ayo saundi nang bundung nga kala muta ko yata bondi o dalilo la kam.
You are right, that may have been the immediate trigger.
Wala ite yemen fo walem o sekeno kutele mi an ko terinke wala
that must have come really hot on the heels of this other judgment.
Yes. But the Dasilame Sangajo case is believed to have been handled by Magistrate Cham, wasn't it?
Dasilame Sangajo la kiti onying mo lara nyina ko Magistrate Cham wale o.
It's Jaite as far as
it's Jaite as well as far as you know. But nonetheless, these are all interferences with the judiciary.
Keta nyara nyimbe mu baral let me yalon ko dabulo lam ye menke na kiti bunda la fanala.
But not only that, there's been several instances of suggestions of bribery of witnesses by state institutions with regards to cases where the state had an interest. What do you say about that?
I did hear about that here at the commission. To be frank, I had not heard of that before. I mean, bribery by the office of the DPP or the prosecutors. But having heard that it happened or it was done by DPP Chenge, I cannot confirm the veracity. What I can say is that DPP Chenge was very desperate to make his mark in this country. And he was in effect a Machiavellian.
Could you break that down for us?
A Machiavellian is a person who is willing to do anything, whatever it takes,
including violating the law.
When we say do anything, it literally means anything in order to get to his end. Yes, and so I will not be surprised, or I will not refute that possibility.
Well, witnesses have accused him personally of bribing them in order to obtain particular testimony. In several cases. Including, I believe, the Langtombong Tamba case. And possibly, was it the Ndur Cham case?
Like I said, I mean, Chenge even had issues with his team of technical assistants that he came with from Nigeria. And there were accusations that he even reported them on, spurious allegations against, in their home country. He didn't get along with even his own people because he was so fixated on doing things that he felt, was going to really, catapult him into, the good books of the regime. That much I can say about it.
But there was also this special litigation team that was at the Ministry of Justice.
Special litigation team
who were paid differently. What can you tell us about that?
Like I said, the Ministry of Justice has been a long-standing recipient of technical assistance, especially from the Republic of Nigeria. And these were people who were sent by the government. But sometime around 2010, before that, these technical assistants are normally paid by their government. And of course, the Ministry of Justice would only pay them the local allowances applicable to locally paid staff.
Ministry of Justice welcoming kadorong ikela allowance lejo komi kajoro kenyame mo lamia ko welmo Gambia dimo beduko.
Around 2010 thereabout.
In 2010 ma fon la katawola.
We suddenly saw a team of 3 prosecutors, lawyers, from Nigeria, who were not sent on technical assistance. How they came into the country, was not known to me, at least. But they were called the Special Litigation Team. And they had their own package, so to speak. They were answerable to the Attorney General rather than the DPP. And then all the politically sensitive cases that were going on at that time were mostly assigned to this state.
Do you know where they were paid from? Was it from Ministry of Justice?
I can't recall exactly whether they received anything from the Ministry of Justice.
Ministry of Justice la fanala.
But certainly, I mean, it was believed that they were actually paid by outside of the Ministry of Justice. Let's say. Outside of the payroll of the Ministry of Justice.
Ministry of Justice
What does that mean? Can you break that down for us?
Well, the Ministry of Justice have got a payroll.
The Ministry of Justice
Basically, I mean, consisting of all the staff of the ministry. Their remuneration. But it was alleged at this time that this special litigation team were actually paid different from the allowances and the remuneration that council received at the Ministry of Justice. There was an allegation not seen their pay slip. They were actually paid in dollars. But that I cannot verify.
By?
I wouldn't know where exactly the payment is coming from. Certainly.
Was it not alleged that they were paid in dollars by the president? Jammeh.
Yes, that's the allegation.
As Solicitor General, do you believe that that was regular and that was legal?
I'm not sure that's the right translation. I wasn't the Solicitor General at the time.
Yes, but as a former Solicitor General.
No, I want to correct the translation. No, certainly. I mean, that would not be regular. All persons working under the umbrella of the Ministry of Justice
Ministry of Justice
must be under the payroll of the Ministry of Justice.
Ministry of Justice
Either as a local staff or as a technical assistant.
At least as a minimum, they should be paid from funds appropriated or approved by Parliament.
Munta futa nyaaw nyarande nyaama to fanna jo nyana nyana bola dula to me alon ko jole me alon ko ministre na député bunnan ko ye budgeto men di ministre même made lual nin tilingola itol fanna nyina jo nyana bola wolto.
That's why I said they should be on the payroll, because the payroll presupposes that it's from the budget of the Ministry of Justice appropriated by the Parliament.
Because niko payroll walen joro ka bonandam and wo joro akabona muntola akata deputy bungotola na botaje aita ministry mialonko welebe marin de paso kenyala dena na futantolma.
So these special prosecutors were just the flip side of the hustler judges.
Amunda nyinki dindirla me alonko be fayene to fana mu molle de me alonko e ninni jojol me alonko e nyindirla jojol e ka fa hustler joji to be mu bebe fanke kulun kin wala kon.
I would agree with that.
Beso nema wala.
And they carried out some of the most abhorrent prosecutions.
Wato do e kayin kiti jawol tale me alonko e kawol e tolle kawol kitindi.
That happened during those days.
You
agree with that?
Certainly. I mean, I think that was the purpose. Why they had to be specially recruited.
But Jammeh did not do this without any support. He certainly would have needed personnel in key institutions to help him do this. What do you say to that? I am looking in particular to paragraph 3 of your statement.
Ite munesada memem fola ila sapa ila kuma kan safe no dala sapa sabanja mo wala jube ka yemem foje.
Yes, that's very true. I think Jammeh treated the Ministry of Justice
Ministry of Justice
like he treated all state institutions. Meaning, he would make sure that he has trusted persons. A lot of times people he probably has a personal relationship with. And make sure that they man key positions in these state institutions. And of course, effectively that would mean that they would be his eyes and ears. And they would probably have direct contact and access to him. I think it was part of the wider strategy of divide and rule, basically. So certainly both at the Ministry of Justice and probably at the judiciary as well, Jammeh made use of the personal relationships he had with lawyers. I mean, to basically, make sure that he is able to have full control over, these legal institutions.
Like you have in the prisons a David Colley, who would do whatever he wanted. And then you have, is it a Yankuba Baji at the NIA? To do what he wanted. And to have an Usman Sonko as Minister of Interior, to do what he wanted, and to have an IGP and a Chief of Staff and a Solicitor General and a Minister of Justice and a Chief Justice and a few judges. Do what he wanted. Dictatorship A101, letter M1. Thank you very much for your testimony.
Thank you very much, Mr. Marena, for your testimony. Very informative and quite engaging. Thank you so much again for coming to testify. Commissioners, if you have any questions, please indicate. Imam C, you have the floor, please.
Imam C,
Mr. Marena,
Mr. Marena, thank you. Your knowledge that you have dispersed here. I have a question to ask you. Based on the, the court proceedings, especially those who are in custody. When we visited the prison, we have realized that there were some people whose case were on up to 10 years now or more. Up to 20 years, still now their cases are still pending. And also in the country here, there are some people, they will come to the lawyer and discuss all what you're supposed to do, you will do them. No document will left behind. But your trial will go more than 10 years. You will go going, coming. Up to 10 years, you are going and coming, and you will not get the truth, and you will not get nothing out of it. This is something that really puzzles me, and I would want you to clear the air for us, since the government of Jammeh up to date.
Thank you, Imam.
Abaraka Imam.
I'll probably speak in English and you do the translation because it's quite technical question.
Okay, sir.
There are a lot of factors. No, I think he speaks Wolof, right?
Somebody is interpreting for you.
Okay, all right. Yeah, I mean, there are a lot of factors responsible for, I mean, the delays in the court cases. One of the, I mean, causes is the lack of adequate judges. I mean, and as a result, you find that individual judges are overloaded. And so the cases take a long time to, I mean, be decided. And sometimes also, when there is a change in the judge that is presiding over a case, I mean, the new judge that comes into a case, if it's a criminal trial, the new judge can actually order a trial de novo, the trial to start again. Because that is allowed under the rules. Another factor is the very manual way of, I mean, recording proceedings. For instance, in the TRRC here, it would not have been possible if this was a normal court for me to be able to give this evidence within this short period of time. Because our courts are still using the manual handwriting system. And that causes a huge delay in the speed at which trials proceed. That is a big factor. Another factor is the endless adjournments that are sought by both defense lawyers and prosecutors or lawyers appearing for plaintiffs. So you find long adjournments being sought by lawyers because they have a lot of cases on their hands. And so the cases take a long time to be concluded. Of course, for those people in remand, another factor could be that when they are taken to remand, the police also may take a long time to conclude an investigation. And unfortunately, there is no system whereby after a case is filed in court and the person is remanded, the judges are able to review, I mean, those cases to make sure that the persons are brought back for trial. So if you are not lucky to have a defense counsel,
so ni ala manne de na lawyer so do mi ko wolbe lole pour que bondi etumi minna,
who can be going to court and raising your issues,
mi ko abe kalata la kiti bunda do ke la ko wol foje,
you will likely spend a long time in remand.
Asikeno ebe mela baka kaso bunda to je.
Because there is just no follow-up.
Kadu ko momantara e banta mi ka bloka wo ko nyin non.
In your case.
There
is also the National Agency for Legal Aid, which is supposed to help indigent, persons who are not able to afford, legal, practitioners or legal representation. But again, the institution is very much understaffed.
And as a result,
they are not able to, deal with as many cases expeditiously as possible.
So,
like I said, it's a real combination of factors, which contribute towards the delays in trials. In this country. Thank you.
Thank you very much, Commissioner Jones.
Commissioner Jones,
thank you, Chairman, and thank you, Mr. Marena, for your testimony.
Chairman, Mr. Marena,
you've spoken extensively about at least 3 laws that Jammeh used to entrench himself in power.
Yeah, for the jang kendeke fon loi sabal mi yalan ko President Jammeh, President Kodonying, wo loi sabal mi akoleta pour ka sembo di afang.
And other than the criminal code, which the criminal offences bill, as you mentioned, is with Parliament or has been with Parliament since December 2019.
For criminal code fanala mi yalan ka be na deputy bongoto ka bring wo watola.
I believe the other 2, as well as several others, are still in use and could be used by any president, be it presently or in future, to entrench themselves in power.
To
the best of your knowledge, at least until the time you were Solicitor General. Do you know if there's any ongoing work to either amend or repeal some of these laws?
Well, like I said, the 2 laws, that is the false information law.
But coming after nyami lual mi yalonko wala lua bundalte mi yalonko coming momi yalonko koye fani alafo.
And the provisions on abuse of office and negligence of official duties.
And dung mol mi yalonko kela doko ke kalanda tambi andi yela inyantela doko kala nyami imanna kya.
Are not separate laws per se. They're all in the criminal code. So the criminal code review has been able to take care of that. The economic crimes decree, I don't think there's any plan to repeal it. Because like I said, it's a decree that has a good legislative intent. To deal with persons whose criminal activity has a great impact on the economy. So it's a matter of application, really. Thank you.
Thank you.
Yeah. Thank you. Imam Jalal, you have the floor, please.
Thank you. Witness, we know the 3 arms of government. Because this sector is very, very important in the country. What you last said about Jammeh's influence on both the bench and the bar.
But ilata kuma kan labangol min fo komi ya Jammeh kay itandiro ko wala kamin dundi komi luala karola ani mol mi yalon ko wollem kiti telalti.
It seemed he used his powers assisted by the laws.
Akamuntalo ko akala sembo nyintale anu sembo nyinga akademaro soto luala fanala.
To twist the arms of all these individuals.
Kanyimol bulota ke be bulambula nyokon.
Genuinely.
Tonya.
Do you think it is wise to still keep the executive to keep control of magistrates, judges, and other persons involved with the execution of the law in a country? Thank you.
Baraka.
Thank you, Imam.
Baraka Imam.
Certainly, there is always a danger when you subject judicial appointments to executive discretion. Even though in almost all countries around the world, judges are appointed by the president. But that must happen only with the sanction or recommendation of the Judicial Service Commission. And so the influence that Jammeh had over the judiciary was as a result of a weakened Judicial Service Commission.
Judicial Service Commission judiciary
if the Judicial Service Commission is adequately strengthened, then certainly there will be less room for executive interference in the judiciary. Even though the president may have the ultimate executive authority to approve the appointments of judges. So I think the key really lies in a very strengthened Judicial Service Commission.
Judicial Service Commission la karola wala multi mialanko ka tombondiro ke molla miya nyanta ka dogo ko kitu ibunda fana to le martala.
Thank you.
Baraka.
Thank you very much. If there are no further questions, Mr. Marena, if you have any concluding remarks, you may please proceed to make them now.
Chairman koso na tara moti je mimbe nyinin kala kote sa eso continue la ila kuma kan labangol di commission o nyati no la jam.
Thank you, Mr. Chair.
Baraka bake, Mr. Chair.
I wouldn't say much.
Nte fenjama fola jam.
I did not prepare any concluding remarks. And I would probably avoid saying by saying it the sterling work that the commission is doing, because like I said, being one of the builders of the institution, that would probably amount to being a judge in my own cause.
Thank
So I'll leave that for other people. But what I just want to say is that what has happened in the Gambia, which is the subject of this commission, is something that we all have to learn from. And I think the solution to never again, doesn't only lie on the governance architecture of this country. I think it has to start with the people, and it has to end with the people. Jammeh was not omniscient. He was not omnipotent. He was not omnipresent. Can you come omnipresent? He wasn't everywhere. He only knew about things. He only made decisions most times based on what we the people told him. It was we the people that spied on each other, that ostracized each other, that labeled each other, that told Jammeh Mr. A is an enemy, Mr. B is a political opponent, Mr. C is doing A, B, and C. And of course, he exploited that. So he would not have been able to do it without the sources of information that was coming to him sitting at State House. And some of this information especially was very, very malicious and wrong. So really, I mean, the never again has to start with us, the people of the Gambia. To strive to be good people, to strive to be our brother's keepers, to strive to be good neighbors to each other. If we do that, I mean, no president, any president killing would feel empowered to basically subjugate the citizens. Like I always tell myself, the difference between Jammeh of 30th November 2016 and Jammeh of the 2nd December 2016 it was the same Jammeh. Why was he so powerful on the 30th of November 2016? And felt so powerless on the 2nd of December? Because the people asserted their right. The Gambians, bold, old and new, old and young, Gambia dingol kebal dindingol wo stood up ilota and defended ilota ka kantarke the constitution na bango loi bukubal and the election results and dum fana karte fayo ni na results ni lota ka tankandi. So even though he had attempted to reverse the results, but because the Gambian people he saw was a different Gambian people he presided over for 22 years, his attitude changed. And so the attitude of a leader is determined by the attitude of the citizens. And that is why I believe a French philosopher had said that every people get the leader they deserve. And so really, I think the people, as long as they show themselves to be deserving of respect, to be deserving of equal treatment, to be deserving of treatment as human beings, that would go a long way in the entrenchment of the never again. So on those on that note, with those few remarks, I want to say thank you for the opportunity of coming here and helping the Commission understand the context and the background to what was happening in this country, in the justice and judiciary sector in the past 2 decades. And I hope that will help us build a bit better system, both for ourselves and posterity. Thank you, Chairman.
Mr. Chair, before the witness goes, I would like to have his statement, his written statement, admitted as an exhibit.
What's the number?
I'll give you the number
later on.
The next hearing. Yes, thank you.
Fine. Thank you very much, my counsel. Thank you again very much, Mr. Marena, for your testimony.
Mr. Counsel. Mr. Marena.
But also a special thanks to you for the contributions that you and your team made in establishing this commission.
Kontondiro fole kontondir kendo mi alan ko ite ni la doku nyol ale wole ka kaje ko nying commissioner nying prae lo